All right, good morning. Welcome to the 294th District Court. My name is Judge Chris Martin. I'm going to call this morning's docket. When I call your name, please say present or here. Apologize for the road traffic and this courtroom and all the other things that are not going right in your life today on Tuesday, February 21st. With that said, Ernest Bowie, for the record, Mr. Bowie will be here at 1:30 this afternoon. Court has given him permission to appear late based on his dialysis. Ryan Dancer, is Mr. Dancer here?
Yes, Your Honor.
Thank you, Ms. Abraham. Samantha Dowling Wise.
Here.
Carl McVeigh, CR 22223, set for arraignment. Mr. White has filed a waiver of arraignment that's been approved. Pretrial is set April 6th. Joseph Blake Moreno. Not at this time, I don't believe. We call Hall, see if Mr. Moreno's here. No. Can you show him in federal custody where, you know, does it say? Kenneth Nash.
Yes, Your Honor.
Thank you.
Judge, I saw that he was released, I believe, from
We've been in Rockwall, then went to
I saw that he was released from Hunt County to federal detainers, but I don't show him in bureau of prisons yet. But oftentimes until they're actually sentenced, it doesn't show up. I can't see if he's just being held. So I don't.
All right, so we can't confirm that he's in custody and he's not here today. Okay. Elkin Martinez.
Judge, that's gonna be a few days.
He's here right now.
5 minutes away.
He's 5 minutes away, Judge.
Shane Adobe.
Yes, Your Honor.
Thank you. Monica Roberts. Lee Garver.
Mr. Garber.
Randy Palmer. Did I hear?
I heard Mr. Keebler and Bill.
Matthew Kearns.
Here.
Takithian Lyons.
Judge, I'm pretty sure he's still in custody.
Yeah. Isn't he still in custody, Mr. Abraham?
That's right.
He's not. Okay. Wants to go back, I guess. Isaiah Smith.
Here. And by counsel, Judge.
Thank you, Mr. Sarver. Jay Penny.
He's here, Your Honor.
Thank you. J.C. White. Jeremy Estridge. So not here. Nathan Capel.
Here.
Seth Atkins.
Here.
Julie Pullins.
Here.
Christopher Watson.
I think he may be in the hall. Is that right?
He's here, Your Honor.
Thank you, Mr. White. Cottrell Higgerson.
Mr. White told me that he was gonna be late. So I'm gonna look again.
Ryan Classen.
He's here. They're going over the paper.
Thank you. CR 22-381, Benjamin Miles. Mr. Wood has filed a waiver of arraignment that's been approved. Pre-trial is set March 28th. William Hayes. Mr. Wyatt. All right, that's all I have on the morning docket. Is there anyone whose name I have not called and you believe that you should be on the docket?
Anyone's name is not called.
No? Okay. All right. Do we have any counsel that's ready? Mr. Schmidt, you ready?
You don't mind coming around this way, do you, John?
I just, yeah, as long as you watch it. High quarter. All right, it's William Hayes, correct? All right, this is cause number CR 22-300 through 306, State versus William James Hayes Jr. I show that we're set for docket call today, Mr. Wyatt.
Yes, Sean.
All right, go ahead. Any announcements?
Yes, Sean, we would like to get another docket setting on. We're working through some mitigation issues that the district attorney and I have spoken with, and with the assistant district attorney this morning. If we could get another setting, I think this would behoove moving this case as quickly as possible.
State.
Say join, Your Honor.
Okay. All right, court will reset Mr. Hayes for an additional docket call. Is 30 days sufficient?
Is there any way, Your Honor, we could have an extra week on that?
About March 28th.
Yes, Your Honor.
All right, that's a Tuesday. That's fine. All right.
Yes,
Court will set Mr. Hayes in all cases for docket call on Tuesday, March 28th. And Mr. Hayes, once you sign and get the yellow copy, you're free to go. Mr. Schmidt, are you ready?
Yeah, Jason White.
I'm gonna stay right there.
That's right. Have you got it?
You may. This is cause number CR 22-298, CR 22-310. All right, any announcements, Mr. Schmidt?
Yes, Your Honor, we're going to execute waivers of the jury trial in the case today. We asked the deputies for a plea on March 28th if possible.
All right, Mr. White, if you will, sir, raise your right hand. I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, you can lower your hand. Your name is J.C. White, is that correct?
Correct.
Mr. White, you are represented by your attorney today, Mr. Brian Schmidt. Are you pleased with Mr. Schmidt's representation of you? And today you talked to him about waiving your right of a jury trial. Is that correct?
Correct.
You understand that you have the absolute right to have your case tried by a jury of your peers?
Yes.
You understand that you and only you have the ability to waive that right.
Yes.
No one can force you to do that, make you do that. Court can't do it. Mr. Schmidt can't do it. The state can't do it. You understand that?
Yes.
You understand that if you waive your right to a jury trial, you're also waiving your right to cross-examine the state's witnesses, confront their evidence in front of a jury.
Yes.
You understand that by waiving your right to a jury trial, you're also giving up the ability to later invoke that right. Meaning that once you give it up now, it may not be restored to you later if you change your mind.
Yeah.
You understand that?
I do.
All right. And Mr. Schmidt, do you believe that Mr. White is competent to enter into this waiver and that he's doing so intentionally, knowingly, and voluntarily?
Yes, to both questions, Your Honor.
State, are you also giving up your right to a trial by jury?
Yes, Your Honor.
All right, and the court's going to find that Mr. White has been admonished as to his right to a trial by jury, that he is also understands in giving up his right to confront and cross-examine the state's witnesses before that jury, and will proceed in this case by plea. Court will find that he has done so intentionally, knowingly, and voluntarily, and the court will approve Mr. White's waiver of jury trials in each case. Court finds that Mr. White has had the advice of counsel and that the state is also joining in on the waiver. Court will set Mr. White then to enter his plea before the court. You said you want that March 28th.
Please, Your Honor.
All right, court sets Mr. White for plea on March 28th. And that'll be, is that a probation plea or a time plea?
Probation.
Probation. So that'd be at 9 AM, and just plan on being here. Not sure where we're gonna be, just plan on being right here. Okay. All right, once you sign and get the yellow copy, you're free to go.
Yeah, thank you, Judge.
Good to see
Thank
you.
you.
Yes, sir. Good to see you.
Good morning, Judge. I was thinking still.
All right, just one second. All right, Isaiah Smith, CR 2279, CR 2282, set for docket call. Mr. Sorry, go ahead.
Yes, Your Honor. I believe we're getting close to getting worked out. We'd like to put on the plea docket.
All right, so what I've got on my docket is today is final docket call. So what I hear is you're close to working it out.
No,
And,
I believe we got to work out, so instead of putting it on the plea docket.
okay, so y'all do have an agreement.
We just need to figure out exactly how much back time he has and figure out those kinds of things. But yes, Judge, I do believe we have a resolution.
Okay. All right, and will this be a morning plea or an afternoon plea?
Morning.
Morning? All right, and you're working out back times, you can be doing time as a condition of community supervision?
Judge, we're working out it appears as though Mr. Smith was incarcerated in the meantime, so he should have a substantial amount of back time. We're working out basically the time share.
Time served, okay. All right, so the court will set Mr. Smith. Mr. Sorry, do you have your calendar?
Yes, sir.
I've got either March 7th, I've got March 9th. Got March 28th,
28 would be perfect.
28th. All right, court sets Mr. Smith then to enter his plea on March 28th at 9 AM. Mr. Smith, once you sign and get the yellow copy, you're free to go.
We get the prosecutor sign this, Judge, or do I need that?
Yeah, you can have them sign it, and then white copy will go here and yellow copy will go to Mr. Smith. Maybe the council is ready.
Yes.
Rob, you ready?
Mr. Kaufman, Lee Garber.
CR 19254, State versus Lee Harrison Garber. So this is a motion for early release from community supervision. Go ahead.
Yeah, we filed a motion for early termination deferred adjudication, show that Mr. Garber never pleaded guilty on October 31st, 2019, and we sentenced to 10 years deferred adjudication. He served until recently paid all of his costs and all his and everything. And I've talked to Ms. Heisel, and she said, "Let me probation agreement from their agreement." We've been back and forth probation, and everybody's the agreement.
So, Officer Mature, you can confirm that the probation department has no objection to Mr. Garber being finally released from community supervision early.
That knows that actually was completed on position.
That he hasn't paid, that he has completed all, and we've got confirmation, so he's paid everything from not only your department, but also the county.
That's correct. Yes.
All fines, court costs, all those things.
Gotta double check. I don't know what they wrote.
Yeah, I don't have any notes, so yeah, if I can get confirmation from the county, do you have any receipts or anything that shows that he's taking care of everything?
Yes, I'm Judge.
Yeah, if you'll get that and bring it back, then I'll take that into consideration.
Thank you, Judge.
Green, doing fine, how are you?
Well, thank you.
All right, this is cause number CR 22224, CR 22225, State versus Monica Rochelle Roberts. So we're set for docket call on 224. I'm not sure what about 225. Go ahead.
Shouldn't be docket call in each case, Judge. Asked for another docket call, Judge. We had reset it last month, so I can visit with Mr. Woodwick about reaching a resolution. And I did a poor job of sending him emails 3 times to the wrong address each time. So I just need a little more time, and I've got the email to him, and he's going to be looking at it. Just need some time to get a resolution.
Any objection from the state?
Your Honor, I don't believe so. I
Okay.
will find some stuff.
All right, court will set Ms. Roberts for a final docket call on March 28th.
So if I just check that day, just to make sure, I think it's fine.
If not, I got the 7th and the 9th.
Judge, I'm actually in judge's seminar that 27, 28, and 29.
What about March 7th or 9th?
I think those dates probably. Seventh at 9 o'clock,
7 and 9 o'clock.
I'd be fine, Judge.
All right, court sets Ms. Roberts in for docket call March 7th at 9 a.m. in each case.
Would we be excused, Judge?
Yes, your excuse. Thank you. Do you have any other attorneys that are ready? Mr. Schmidt, ready? I'll do great.
Never gonna get it, never gonna get back home.
Probably not. Probably find you home. I have to get a big one. Mr. Wright, are you ready? All right, let's go with Julie Pullins, CR 22-361.
Your Honor, I have filed a pre-trial motion. The only thing I don't have is the DVD of this case. I could probably wind up getting that if we want to put it on a docket or pre-trial.
All right, has Miss Pullins been arraigned yet? I'm not, I have her set for arraignment today, but
We did it in
do we do it
person.
last time?
I didn't have enough time to file a waiver, so we can do it again if you want to make sure.
No, you said we did it at the last setting?
Yes, we did. Your Honor.
Okay. My docket just probably didn't get updated. All right, so. And so you said no, you said you filed your standard pretrial motions, no contestants. Okay. All right, then the court will set Ms. Pullins in for docket call. Are you available on that March 28th date?
I certainly am.
Okay. Court sets Ms. Pullins in for docket call on March 28th at 9 a.m. Christopher Watson, CR 22-198. Yeah, Mr. Watson.
Your Honor, this is a second pre-trial. We've had an opportunity to have everything that we need to do. I didn't file any additional motions that I did last time, but it was not. I just all agreed to that. So I believe we can set this word out.
Court sets Mr. Watson then for docket call on March 28th at 9 a.m. Once you sign and get the yellow copy, you're free to go. Seth Atkins, CR 22-1, CR 22-236, CR 22-368. Show that Mr. Atkins is set for arraignment on the 368, which is an assault, family household member by impeding breath, a third degree. Don't know.
Well, I went ahead and filed my motions anyway for the pre-trial. I can't independently recollect if we did this in court or not, because I know I didn't file. But I have no problem going through the arraignment at this time. We have gone quite extensively as far as plea negotiations and think we have some things, but there are any time would be
me see if I put any notes in my system about him getting arraigned. Mr. White, I feel the last time that we were set on this case was in January, and Mr. Atkins was to retain counsel. So let's go ahead and arraign him. If you want to, I'm going to share the screen, and you can step up here for the document. You have a copy of the indictment, Mr. White?
I believe it did, Your Honor. Your Honor, we looked over the indictment. We are the same person that's charged with the offense. Everything is done correctly. We do not need to state and read this to us. And we would waive any other formalities as far as arraignment goes.
All right, court will find that Mr. Atkins has waived the formal requirements of arraignment in CR 22-368. Court will set Mr. Atkins for pretrial. In that matter, the court will carry the other two cases for pretrial as well. March 28th.
Good, Your Honor.
We set Mr. Atkins for pretrial March 28th in all cases at 9 a.m. And Mr. Atkins, I'm showing that there's a warrant for your arrest for violation of a protective order, Class A misdemeanor. So you're going to be taken into custody at this time. You'll get all that information. That's just what they give me, so. Schmidt, good morning, sir. Fine, how you doing? Who'd you like to go on first?
Estridge.
Jeremy Wayne Estridge, CR 21, I'm sorry, CR 11-119. Good, Mr. Schmidt.
We're here on MTA on Mr. Estridge. The primary issue is a restitution issue. Roughly, my recollection is about $100,000. He's paid roughly half of that. We're going to ask for extended use. We're hoping to get the remainder paid off after taxes and over. So you asked that this be set late March.
All right, court, any objection from the state? All right, court will set Mr. Estridge for a status on his motion to revoke March 28th. It's a Tuesday. That'll be at 9 a.m.
Nathan Cavapilli.
Nathan Cavapil, CR 22-220-221-231. This, I believe, we're set on our status for a pretrial release, or is there another issue?
We we were also reviewing some of the discovery and discussions. I think we're pretty close to there. I found when I was looking for the discovery videos and I believe we're also set on the 7th already. We had 2 settings, one for this status and then one for Docket. We're ready to enter a plea, and I think we're gonna read that on the 7th.
On the 7th? Will he be executing a waiver of jury trial today?
I intend to judge that. Certainly could. Or like that document.
You said that would be on the 7th, enters plea on the 7th.
Yes, sir.
Waiver of jury trial today, court probably would not take up the pretrial release issues today. Otherwise, court may take the pretrial release issues up today.
Yes, sir, I understand. Visit the state briefly and then it's about if you could read policy.
All right. Have a seat, Mr. Caphill. We'll be calling in just a moment. Mr. Yuba, good morning, sir. How are you?
How are you doing?
Good. I'm doing great. How are you doing?
Feeling well. Here on Brandon Palmer, 22-386-387. Except for pre-trial, this is the first setting. I've been talking to Ms. Murray about the case. We got a termination pre-trial. I know the court's going to sign it with March 28th for us.
Okay. Has your client been arraigned on the cruelty to non-livestock? I'm showing CR 22-387.
Also, that was waiver of plea was signed on January.
Let me double check that.
I know both were submitted. It may have been standard and cost for your honor, both cause numbers.
Yep, I do see it there. Okay. All right, court, we'll set Mr. Palmer then for pre-trial, actually, so, yeah, let's see, the arraignment's done. So you said you received all your discovery.
So far, I think we're still trading information. I've not been.
Okay. Do you need another pre-trial setting?
Yes.
All right, court will set Palmer for an additional pre-trial setting on March 28th at 9 a.m. And I'm not sure where we'll be, Mr. Ugler. We'll just anticipate right here somewhere in this vicinity of the courthouse. All right, thanks. You may be. Good to see you.
Good to see you.
You're welcome. Here you go, Mr. Huber. If they've already signed it, you can leave me the white one and give him the yellow one.
They haven't.
They haven't. Mr. Hobbs, you ready?
Mr. Garber's on. I'm waiting for it. I've got different one. But he went on to just make sure most of the documentation that everything's on it. He wrote out. Perfect. He should be back.
Okay, sounds good. I appreciate that.
Selling autographs. Either. Yeah, I'm trying to involve him through today.
Right now.
If you've got them, millisecond. Thank you, sir.
Dallin Wise, number the third one. She's talking to you going about retaining.
Just got back. Got this too.
I mean, if you're done, it's- Yes, sir.
All right, and the cause number. CR 19254. Court finds that there's no objection from the state or the probation department with regards to the motion for early release from community supervision. Court finds that Mr. Garber has satisfied all conditions of community supervision, including all payment of financial fees. Court hereby grants the motion for early release. And do you have that on files or in order on
I
file?
haven't filed it. I just printed it out before, and I'll go file it after this. Actually, it might be filed, Judge. I didn't know which one you wanted to do. I apologize.
All right, court has signed the order terminating community supervision. I'm going to return. I'll leave this here for filing, Mr. Hobbs, and then we'll take it upstairs in just a moment.
Okay.
All right.
Thank you, Judge. May I excuse?
You may be. Thank you, Mr. Carter. You're free to go. Yeah, just one moment.
There's the plan.
Okay. All right, good morning. Mr. Hyde, how are you doing?
Good to see you.
How are things in the Sulphur Springs area? You Greenville and all that good area, everything? Good. All right, this is cause number CR 2199, CR 2324. State of Texas versus Matthew John Kearns. Mr. Kearns, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
All right, thank you. Lower your hand. Speak up loudly and clearly for me. Mr. Kearns, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with a mental condition?
No.
In this case, you're represented by your attorney, Mr. Heath Hyde. Are you happy with Mr. Heath Hyde as your attorney?
Yes.
You feel like you've had enough time to talk with him about your case and have all of your legal questions answered?
Yes.
Is there anything about the paperwork that you've read over and signed today that you do not understand? Mr. Hyde, do you believe that Mr. Kearns is competent to enter into this plea agreement and that he understands the waiver of rights he's making? And also have you explained to him the advantages and disadvantages of a deferred adjudication plea?
Yes, sir.
All right, Mr. Kearns, you were originally charged with a third-degree felony offense of hindering a secured creditor greater than or equal to $30,000, but less than $150,000. However, I see that the plea agreement today is that the state is recommending that the court grant a dismissal in that case, the third degree hindering secured creditor, and for you to enter into a plea agreement in cause number CR 2324, which is filed by information, a class A misdemeanor offense of false statement regarding property or credit greater than or equal to $750, less than $2,500. It appears that you would be pleading no contest to that crime, that the court would consider the evidence and then defer a finding of guilt and place you on community supervision for a period of 2 years, and you would be responsible for your court costs, reimbursement fees. Is that your understanding of the plea agreement?
Yes, sir.
All right, Mr. Hyde, yours as well?
It is.
State yours as well?
Yeah.
And there's no restitution claimed in the case?
That's correct.
All right, Mr. Kearns, then, understanding the range of punishment for a Class A misdemeanor, which is if you were to be convicted of this offense, a Class A misdemeanor offense, then the court could assess punishment anywhere from 0 days up to 365 days in the county jail, and could assess a fine up to $4,000. Do you understand that?
Yes, sir.
You understand that if I approve this agreement, that if you're on your community supervision and you violate any of the terms of your community supervision, the court could conduct a hearing. If the court finds that based on the evidence you violated, the court could revoke your community supervision, could convict you and assess your sentence up to a year in the county jail.
Yes, sir.
Understanding all that, you still wish to go forward?
Yes, sir.
All right, then, Mr. Kearns, how do you plead to Class A misdemeanor false statement regarding property or credit, $750 up to $2,500?
No contest.
Are you pleading no contest, and you understand that a no contest plea will be treated legally the same as a guilty plea by the court if accepted?
Yes.
All right, and Mr. Kearns, you've had sufficient time to talk to Mr. Hyde about this case. In your no contest plea today, you're doing so because that's what you want to do freely and voluntarily. Is that correct?
Yes.
All right, the court will accept Mr. Kearns' no contest plea. Mr. Hyde, any objection to the state's evidence?
No, Your Honor.
The state's evidence supporting the plea and stipulation is admitted. The court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Yes, Your Honor, the state is compliant with victim notification, however, we have needed to submit to the court this time on them.
Thank you, Ms. Heisel. Anything further from the defense? All right, the court's going to review the evidence briefly. All right, the court has reviewed the evidence. The court finds sufficient evidence to convict Mr. Kearns of this offense. The court will follow the plea agreement between the state and the defense. Court will defer a finding of guilt on the Class A misdemeanor offense of false statement regarding property or credit. Court will place Mr. Kearns on 2 years community supervision, order him to pay $270 court costs and $15 reimbursement fees. Okay, you are going to need to fill out all of the plea papers regarding the plea and the level. None of this is filled out. Y'all have all signed it this morning to it, but there's nothing filled out here about the charge, the class,
I'll do
the plea agreement, anything.
I see that just that front page.
Are there conditions of community supervision with this? I didn't see that.
They've got them. That should be it, Your Honor.
Sir. All right, Mr. Kearns, you hereby remanded to the custody of the Van Dyke County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted with Deputy Everett.
Good seeing you.
You can see him.
Doing good. I don't think I have any cases here, so maybe next time I come through, I'll take you. We can go to lunch when okay, that'd be good.
Mr. Fred, are you ready? Mr. Adams, are you ready? I haven't seen anybody jumping, so.
Yes, I'm ready.
All right, come on, Mr. Carter.
May we approach?
You may. This is cause number CR 22-130-131, State versus Shane Adobe. Separate docket call. Go ahead, Mr. Frederick.
Your Honor, so it's my understanding, Thursday that the district attorney's office contacted Mr. Stevens to let him know that our replacement hard drive has been completed, so we're gonna pick that up today. That is the drive that I think is the redo of the first round of discovery, as well as some new discovery. Okay, we have had issues with the first round of discovery. I submitted a second drive, and so we're picking that up today. So for that reason, we're asking for, hopefully this can be the last Docket call, so I can now go through it. And I told Ms. Heisel, we've been having issues with just certain material where it just won't load, just keeps spinning. And so I'll go through again the second drive, see if that's still happening, and then make a very quick list, get it to the DA's office, so that we can just, isolate the specific instances of what we're missing and now what we have. But this should be the last time we're having issues with discovery.
And Judge, say, legal assistant watched all the videos to make sure they play on our devices. The co-defendant's attorney has also confirmed that they all work on his devices. So if for whatever reason they don't work on Mr. Bratter's computer, we also offer for him to come into our office to view him if there's compatible issue with his device. But we have recopied that, and we intend to get everybody all the material. There was also some confusion about the portal, which we've resolved since. So save would join in an additional docket call, just because we have kind of had some kinks to be ironed out, but I think we're very close, if not gotten worked out.
Are you available on March 28th?
Yes, Your Honor.
Okay. All right, court will set Ms. Dobie for additional docket call on March 28th at 9 a.m. And once Ms. Dobie gets the yellow copy, she's free to go.
Thank you.
You're welcome. You may.
Yes.
Mr. Estrada,
Morning, Judge.
good morning. How are you?
Good.
All right, this is Mr. Martinez.
Yes, Judge.
All right, this is cause number CR 22-307 and 277. State versus Elkin Martinez Cornelio.
If we could recall this, I saw a mistake and I'm fixing really fast. It should take me 3 minutes, but I just want to correct it. I'll give it to Mr. Estrada. He's all signed up. I just need to change one thing. I want to say, make him fully aware of what I'm fixing
Okay.
and then we'll bring it.
Okay, I'll recall your case in just a moment. Mr. Adams, you ready?
Ready.
Kenneth Nash, CR 22-71. All right. All right, Mr. Adams, I believe this is a motion to clarify.
Yes, Your Honor.
Go ahead.
Mr. Nash was originally charged under, or indicted under section 22-021 of the Penal Code. Last year, we pled him out to injury to a child to avoid chapter 62, chapter 62 of registration violations. Since that time, there's been some user questions about the terms and conditions of the probation. Rather than me give him bad advice, I have to answer to a writ down the road. That's to come to the final arbiter of all things, with the probation conditions, that being you, so that you know exactly where we stand. But it's the
What's the objection? I mean,
I'm told that he is being asked to sign a document, and I don't have a copy of it, so I don't know what it says.
well, let's stop and let's get that. Mr. Waddell, can you get us a copy of the proposed amendment to the probation conditions of Mr. Nash? I vaguely remember having a discussion with the probation department because they had a concern based on the offense and the stipulation that was provided. And I think they just requested counseling, them to be placed in counseling. And so I think I approved that, but I want to make sure that we get that.
Yes, and we have no issue or complaint about that condition. It beats the alternative, Lord knows. There was a question as to whether signing the document in question would require Mr. Nash to have to leave the residence where he lives with his wife and my children.
Yeah, let's get the document. We'll see what it says. As soon as we get that, I'll recall your case.
Yes, sir.
All right, gonna have a seat. Can you tell, Carl or Rachel?
Mr. Martinez.
Oh. Soon. Mr. Woodward, I have a question about the plea papers and CR 22-277. You may. So the charging instrument information, but it's an indictment. I think you should say indictment. You should say lesser included to a lower charge. That way we reflect it in the plea. And otherwise, it looks like he's pleading guilty to the information.
Yeah,
He was charged on indictment, so.
yes,
We need to have that.
I will fix that as well, Judge.
I think that's the point. But yeah, I think it'll say indictment here. You have your original charge and then it'll just drop down. I will say this or the. So this may say indictment and then. Is this gonna be? Is this gonna be a state jail?
It's a state jail and then doing 1244A. 1244B.
1244B, so it'll be treated as a misdemeanor punishment.
Yeah, so I think that should say indictment.
Yes, Judge.
And you have that's your state jail.
Yes,
This would say.
state jail.
Felony.
Mhm.
And it would say 1244B.
However the court would like it. I
Can
can
we
fix
get
it.
that fixed?
Do you want to write in there exactly what you want so I can make sure I do it how you want?
I'm just gonna agree.
Yes, state jail felony dash 1244B. Yes, Your Honor.
And this one is an additional, because it's a
Yes.
DWI.
It's the DWI first.
So that's right. He's got his 3 days.
Yes, Judge.
And they no longer makes to put what dates they have. right?
No, that's correct.
All right, yeah, if we get that fixed, then I'll recall it back up and we'll have them go over.
This one.
everything, so we understand. So, we hold on to these and just give you that.
It's however you'd like to do it, Judge. Why don't you just give me all of it, just so we can keep it together?
Yeah.
Sure, sir.
Thank you, sir.
All right, go ahead and have a seat and we'll recall your case in just a moment. Okay, thanks. All right, do we have any other counsel that's ready?
Your Honor, I have a request. I represent Mr. Kenny. He's outside the courtroom. I filed a motion to suppress.
Here, let's go ahead and bring him in. CR 22-390, State versus J. Warren Penny. All right, go ahead, Mr. Patton.
In your honors, it was my understanding, speaking to DA, that the court says contested cases, I guess there's 1 day set aside for, I guess, things like motion stress, which is this Thursday. If you stay wouldn't work, and the next one will be the 27th of March. And that's good with me, other than I have a hearing in Gregg County that morning.
I think it's March 30th.
Oh, 30. All right. But it's good.
30th work. Okay. All right, court will set Mr. Penny's motion to suppress for evidentiary hearing on Thursday, March 30th. We'll do that at 9 AM in this court. And so once you sign your notice and get the yellow copy, you're free to go.
Right, thank you.
Mr. White, are you ready?
Yes, sir.
Who are you ready on?
Let's do Mr. Hickerson first.
Cottrell Hickerson, CR 22-105. Go ahead, Mr. White.
Your Honor, we're setting following the state's been joining me. We're gonna ask them to look at one final document called Mr. Hickerson. We're just trying to work this out without the need for trial.
All right, court will set Mr. Harrison for a final docket call. Are you available on March 28th?
Yes.
That'll be at 9 a.m. And Mr. Harrison, have you signed your conditions of pretrial release? You have not. All right, you'll need to do that today. Mr. Waddell, behind you is with the pretrial release department. The bill that you posted in this case will have conditions on it. You'll have to report, you'll have to drug test, you have to maintain all of those conditions so that you can stay on bail during this case, okay? All right, so once you sign this, get the yellow copy, see Mr. Waddell, sign your conditions, then you're free to go. All right, you ready on Classen? Ryan Matthew Classen. I didn't help you at all. If I moved that way. It's going to-
As long as I see that.
Something for the future if you want, so that I can help you set up here. I can do from that if you want, but I would also wrap all that there. All right, Mr. Classen, sir, if you'll raise your right hand, I'm place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So if you got, all right, thank you. You can lower your hand. Just speak up loudly for me. Windows open, it gets loud. Court reporter here has to take down everything we say, okay? All right. As I said before, this is cause number CR 21-331, CR 22-59, State versus Ryan Matthew Classen. Mr. Classen, are you a United States citizen who reads, writes, and speaks English?
I'm not a US citizen.
You're not a US citizen. My recollection is you're a Canadian citizen, is that correct? And have you taken the opportunity to talk with Mr. White and or any other attorney regarding the immigration consequences of you accepting or admitting to any guilt in either one of these cases? And Mr. White, can you assure the court that Mr. Classen has taken those steps, or you've given him that counsel?
Yes, sir. We talked about this. Satisfied. I mean, obviously, Mr. Classen knows that when he gets down to immigration, there are really no bright line rules, and he's in the process of trying to become naturalized. He understands that this could possibly go rich.
So, Mr. Classen, you understand that you accepting guilt or admitting guilt or acknowledging guilt or pleading guilty could have a negative consequence on your status within this country that could result in deportation, amongst other things. You understand that? And you understand that once you go forward, and if the immigration courts decide to take some type of adversarial action against you, that would not be a ground for having your pleas in these cases withdrawn. You understand that?
Yes.
And understanding all that, you still wish to go forward?
Yes.
All right, and you've taken the time to read over all of the paperwork today. Is there anything about the paperwork that you've read over and signed with Mr. White's counsel that you do not understand?
No.
Are you pleased with Mr. White as your attorney?
Yes.
Mr. White, do you believe Mr. Classen to be competent today?
I do, Your Honor. I would be confident that he understands the proceedings of any of these 10 years.
Right. And you believe he also understands the advantages and disadvantages of a deferred adjudication plea.
Yes, sir, I've gone over the advantages or disadvantages of the deferred adjudication plea. Most notably, if he violates the term and condition before, and the court finds that he did so before adjudicating guilty and having entire range of punishment at his disposal, which is up to 180 days, and the fine not to exceed $2,000. Additionally, if he violates his probation, that's probably going to void his PPI contract with the state. We've gone over that as well, understanding that he's given up some rights there, including the right to a jury trial, limited waiver of dysfunction, and what kind of right to a speedy trial. And we're also stipulating to the evidence occasion, Your Honor, and I've explained this class. With that stipulation, it makes it very, very easy for the state to prove this case.
Thank you, Mr. White. Mr. Classen, you've heard everything that your attorney, Mr. White, has said today, and you agree with what he's telling the court as to your understanding of those things.
Yes.
All right, then in cause number CR 2259, Mr. Classen, you are charged by information with a Class B misdemeanor offense of driving while intoxicated. The legal range of punishment for a Class B misdemeanor is up to 180 days confinement in the county jail, and also a fine not to exceed $2,000. I see in this case that you would be pleading guilty to that crime, and the state would be recommending that the court review the evidence, and if the court finds enough evidence to convict you today, that the court defer a finding of guilt. That means not convict you today, but rather to place you on 2 years of community supervision, along with fines, court costs, reimbursement fees, and restitution. And a forfeiture of a weapon from the unlawful carrying of a weapon case, which would be dismissed by the court upon the state's recommendation in DA number 2021-435. That's your understanding of the plea agreement in that case. Is that correct? And you understand, as Mr. White has aptly put, if the court accepts this plea agreement and you violate any of the terms and conditions of your community supervision, the state could file a motion with the court. We could bring you back to court. The court could hear that evidence, and if I find that you have violated, the court could do a number of things, including adjudicating your guilt, finding you guilty, revoking your community supervision, and assessing your punishment anywhere up to that maximum 180 days in jail. You understand that?
Yes.
All right. So, Mr. Classen, in this cause number, then how do you plead to driving while intoxicated?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes.
Has anyone threatened you, forced you, or pressured you to plead guilty?
No.
All right, court will accept Mr. Classen's plea of guilt in this cause. Mr. White, any objection to the state's evidence supporting this case?
No, sir.
Stipulation of evidence is admitted. The court takes judicial notice of Mr. Classen's judicial confession in this cause. Mr. Classen, with regards to cause number CR 21331, you are charged by indictment with a felony offense of possession of a controlled substance in penalty group 1 greater than or equal to 1 grams, less than 4 grams. The range of punishment for this offense, which is a 3rd-degree felony offense, is confinement in the Texas Department of Criminal Justice for a period of not less than 2 years or more than 10 years, and a fine not to exceed $10,000. You understand that range of punishment?
Yes.
And it appears to me in this felony, 3rd-degree felony possession of controlled substance case, that you and the state want to enter into a pretrial intervention contract for a period of 2 years. You've taken the time to read over this contract with Mr. White, is that correct? As Mr. White stated earlier, you're waiving several rights within this contract, and you understand that?
Yes.
Some that are very specific in their own documents are, not only are you stipulating to evidence the admissibility of things which might not otherwise be admissible in court, you're also waiving your right to a jury trial, which only you can do. And you're also waiving your right to a speedy trial, and you're also waiving your right to have your criminal records expunged with the DA's office and the probation department. And you understand those waivers that you're making today?
Yes.
And has anyone threatened you, forced you, pressured you, made you feel like you had to make any of those waivers today? All right, the court will find that Mr. Classen has intentionally, knowingly, and voluntarily waived his right to a jury trial, a speedy trial, and also limited waiver of expulsion. The court will approve those waivers. Court will approve Mr. Classen's placement in the pretrial intervention program for a period of up to 2 years. All right, court's going to review the evidence and cause number CR 2259. All right, court has reviewed the evidence. Court finds that there is sufficient evidence to convict this defendant. The court will follow the plea agreement between the state and the defendant. Court hereby refers the finding of guilt on Class B misdemeanor driving while intoxicated. The court will place Mr. Classen on 2 years community supervision, order him to pay a $1,000 fine, $240 restitution, $15 reimbursement fees, $270 court costs. Court also takes into consideration DA 2021-435, unlawful carrying of a weapon. The court will order the forfeiture of that weapon within this plea agreement. Mr. Classen, you're lucky to be alive.
Yeah.
After reading this, you're lucky to be alive. And I would say probably some other people around you were lucky to be alive. So I hope this is a wake-up call for you. It really is a new lease on life. Because there's been many people that have gone before you that haven't walked away from something like that. They haven't walked away alive, and those that have walked away haven't walked away. So I hope that you appreciate the opportunity that Mr. White has secured for you with the DA's office, and that you do what you're supposed to do so you don't waste this new lease that you've been given. All right, Mr. Classen hereby remained to the custody of the probation department so they can carry out the terms and conditions of the sentence, and then you come up to be fingerprint of Deputy Everett, and then the probation officers will give you more.
Thank you. Your Honor, that's all I have.
Yes, thank you, Mr. White. Appreciate you, sir. Mr. Shawton.
Yes, sir.
All right, we are on record CR 22-307, CR 22-277, State versus Elkin Martinez. Cornelio. Mr. Cornelio, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today would be the truth, the whole truth, and nothing but the truth? So if you got.
Yes, Your Honor.
All right, you can lower your hand. All right, Mr. Cornelio, just make sure you speak up loudly and clearly for me. All right, your name is Elkin Martinez Cornelio, is that correct? You go by Mr. Martinez? You go by Martinez?
Yeah.
All right. And Mr. Martinez, are you a United States citizen who reads, writes, and speaks English?
Not a United States.
Okay. You understand that any admission of guilt, acknowledging guilt, or entering or any finding by the court of your guilt could have adverse effects on your status within this country?
Yes, Your Honor.
And have you taken the time to consult either Mr. Estrada or any other attorney about your legal status and what consequences may flow from your actions today?
Yes, Your Honor.
All right. And Mr. Estrada, have you counseled Mr. Cornelio on, or Mr. Martinez on the immigration consequences of any acknowledgement of guilt?
Your Honor, we are in compliance with 50 versus Kentucky. We've had numerous conversations regarding the collateral consequences to entering into a plea today.
Okay. All right. And Mr. Martinez, you've read over these documents with your attorney, Mr. Estrada, today.
Yes, Your Honor.
And you understand everything that you've read and signed?
Yes.
Do you have any questions about these documents?
Your Honor.
Mr. Estrada, do you believe that Mr. Martinez is competent to enter into these plea agreements?
I do believe him to be competent, Your Honor. At all times, he's been able to actively discuss any affirmative defenses. There's actually a suppression motion that's on file that now that we're entering into the plea agreement, we would be withdrawing that suppression motion. He's been able, he understands the range of punishment, the effective entry of a guilty plea, Your Honor.
All right, Mr. Martinez, then in CR 22-277, you are charged by indictment with a state jail felony offense of possession of a controlled substance in penalty group 2, less than 1 gram. I see the plea agreement in that case is that you would plead guilty to that crime in exchange for the state's recommendation that you plead to the lesser included offense of possession of a controlled substance in penalty group 2, less than 1 gram under section 1244B of the Texas Penal Code, with your punishment being assessed at 3 days in the county jail. You would receive 3 days of credit already for time served. In addition, you would pay a $650 fine, $180 restitution, $270 court cost, and $35 in reimbursement fees. Is that your understanding as well, Mr. Martinez? In cause number CR 22-307, you're charged with driving while intoxicated, a Class B misdemeanor. A Class B misdemeanor carries a range of punishment of not more than 180 days confinement in the county jail and a fine not to exceed $2,000. I see the plea agreement is that you would plead guilty to that crime in exchange for a sentence of 3 days confinement in the county jail, with you receiving credit for 3 days of time already served, a $100 EMS trauma fine, plus court costs and reimbursement fees. Is that your understanding of the plea agreement in that case?
Yes, Your Honor.
Yours as well, Mr. Estrada?
It is, Your Honor.
All right, then, Mr. Martinez, understanding the potential adverse effects regarding your immigration status or legal status within this country, and you acknowledging the range of punishment and your understanding of the plea agreements, I ask you at this time, how do you plead to the state jail felony offense prosecuted under section 1244B as a Class A misdemeanor of possession of a controlled substance in penalty group 2, less than 1 gram? Are you pleading guilty to that crime because you are guilty of committing that crime and for no other reason?
Yes.
And has anyone threatened, forced, or pressured you to plead guilty to that crime?
Okay.
With regards to the Class B misdemeanor offense of driving while intoxicated, how do you plead?
Guilty.
Are you pleading guilty to that crime because you're guilty of committing that crime?
Guilty.
Has anyone threatened, forced, or pressured you to plead guilty to driving while intoxicated? All right, the court will accept the defendant's plea of guilt in each case. Mr. Estrada, any objection to the state's evidence supporting each plea?
No, Your Honor, no objection.
All right, state's evidence is admitted in each cause respectively, and the court takes judicial notice of the defendant's judicial confession in each case. Court's going to review the evidence. Anything further from the state at this time?
No, Your Honor, we addressed in closing policy.
Anything further from the defense?
No further evidence, Your Honor.
All right, court's gonna review the evidence. All right, the court has reviewed the evidence, finds that there is sufficient evidence to convict the defendant of each cause. The court will follow the plea agreement in each case. CR 22-277, the state convicts Elkin Martinez Cornelio of possession of controlled substance in penalty group 2, less than 1 gram. Court assesses punishment pursuant to the plea agreement under section 1244B of the Texas Penal Code as a class A misdemeanor. Assesses sentence at 3 days confinement in the county jail. Gives Mr. Martinez 3 days credit, orders him to pay a $650 fine and $180 restitution, $270 court costs, and $35 reimbursement fees. The court also dismisses under section 1245 DA 2022-554, prohibited substance and correctional facility, DA 2022-553, possession of marijuana less than 2 ounces. Cause number CR 22-307. Court convicts Mr. Cornelio of driving while intoxicated, a class B misdemeanor offense. Assesses punishment under the pursuant to the plea agreement at 3 days confinement in the county jail, issues him credit for 3 days of time served, orders him to pay a $100 fine. $270 court costs, $35 reimbursement fees. All right, Mr. Martinez, you're hereby remanded to the custody of the sheriff so we can carry out the terms and conditions of the sentence. You may. Thank you, Mr. Shaw. Mr. Schmidt, you ready? Mr. Capville, CR 22-220-221-231. All right, Mr. Capville, if you'll raise your right hand, I'm going to place you under oath. So do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can log in. All right, Mr. Capitol, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt's representation? And today you've discussed with him a waiver of jury trial, and you've signed 3 documents. Is that correct? And in these documents, it indicates to me that you understand that you have the right to have your case tried by a jury of your peers. And you also understand that you can waive that right. And if you waive that right, that you would be waiving the right to confront and cross-examine the state's witnesses at a trial of your peers. You understand that? And you understand that if you waive your right to a jury trial, the likelihood of you having that right restored to you in each one of these cases is very limited. You understand that? And today you're electing to waive your right of a jury trial in each one of these cases. Is that correct? Is there anything about these documents that you've read over that you do not understand? You know, you doing so intentionally, knowingly, and voluntarily. Court finds that Mr. Capitol has been admonished as to his right of jury trial. Mr. Schmidt, you joined in with Mr. Capitol on entering into these waivers. Is that correct?
That's correct.
State, you're waiving your right to a jury trial in each one of these cases.
Yes, sir.
All right, court will approve the waiver of jury trial in each case. Court will set, are we already set on the 7th?
Judge, I've got a recent number, so we'll just go ahead and do it just in case we on 7.
All right, court will entertain the plea agreements of Mr. Capitol and the state on March 7th at 9 a.m. Is it 9 a.m. or 1:30?
9 a.m.
9 a.m.
Mr. Capitol, free to leave, Judge.
Let me make sure I don't have any other notes. Yes, he is free to go. We'll see you back on March 7th. Thank you, Mr. All right, Mr. Gann, do we have the proposed amendment to the conditions for?
Talk to him and his attorney.
All right, Mr. Adams, let's just, you have a seat, Mr. Nash. I want to just talk to Mr. Adams. Come on up. We're going to talk off the record. All right, this is in cause number CR 2271, State of Texas versus Kenneth Ray Nash Jr. The court signed an amendment to the conditions of probation on December 15th, 2022. Which did a couple of things. One, it waived the anger management course. And then it added that Mr. Nash is to submit to an evaluation by a public or private mental health service provider to determine the need for psychological counseling and or sexual offender evaluation and counseling, and to prescribe a course of treatment and continue said treatment until successfully discharged by permission of this court. And that the defendant will be responsible for all the expenses incurred and for the release of the evaluation results. And that Mr. Nash would need to be enrolled in that program within 10 days of being placed on community supervision or signed of the signed amendment. So the court has ordered that on December 15th. It's my understanding, Mr. Adams, that your client, Mr. Nash, is reluctant to sign this because he has some concerns. Is that correct?
That's correct.
Can you go ahead and just put those concerns on the record?
Certainly. Considering the nature of the original charges indicted, it's not surprising that such an evaluation would be ordered as a condition of probation. This would be akin to a drug and alcohol evaluation being ordered as a condition of probation for someone convicted with driving while intoxicated or less than the offense. What was a surprise to us was that the Van County Adult Probation Office would require Mr. Nash to reside somewhere where there are no minor children while the results of that evaluation are pending. It is understandable that the results of that evaluation might require him to reside somewhere where minor children, might exclude him from a residence where minor children reside based on the results of the evaluation. But it is a surprise to us, and that's certainly understandable. It is a surprise to us that the exclusion from residences where minor children reside would be required while those results are pending. Mr. Nash has been on up until the day of his entering and pleading once concluded office in December. He'd been on a PR bond for several months, living at home with his wife, his 3 children, 2 of whom are minors, a 22-year-old and one's recent newborn. That living situation brought along instant problems or complications while he was on that PR bond. And since he entered his plea in December, there's been no contact with the PS or allegations or any outcries or anything of nature. We would ask the court to consider waiving the requirement that he not reside in his residence with his minor children while those results are pending. And we understand that those test results or evaluation results can take a week to 2 weeks to come back. It's a personality evaluation index or an ASSI. It's not just turn around overnight. And because of that, and because of the good track record that we've got in Nash residents, that it would be appropriate for the court to waive that particular aspect of the probation of the customary probation conditions. As I said, it might be understandable that would be appropriate pending those results. However, the results may show that there's no need. And that's what we expect.
All right, and the state has consulted with the Van Zandt County Community Supervision and Corrections Department, and the court understands the policy of the department regarding the removal of Mr. Nash from the presence of minors during the pendency of the evaluation. The court is going to absolve the department of any policy complications. Court is going to allow Mr. Nash to remain in the presence of his home with his wife and kids pending the results. Now, if the results come back and the provider recommends that a different course of action be taken, then the court's going to consider that and will conduct a hearing if need be on that matter. So for the time being, the court's going to allow Mr. Nash to remain at home with his children. And then, like I said, we'll reevaluate it once the evaluation comes back. So, Mr. Nash, I'm not going to make you sign this if you don't want to. However, the court has amended the conditions of your community supervision, and you're required to submit to the evaluation. Failure to do so would be a violation of your community supervision conditions. Okay. All right. All right, so if there's nothing more, then we'll be adjourned, and then pending the results of the evaluation, and then we'll set another hearing if necessary.
Pretty good.
Okay.
Thank you, Your Honor.
You're welcome.
That's all I have for you this morning. Everybody's here.
Yes, you may. Thank you.
This is
Mr. Gann, do you want these? This is your copy. You want that file? Okay, well, I think it's already filed record. Okay. All right, we're free to go. Sorry. You're welcome.
Yeah, see all of it.
Mr. Dancer, you'll come on up. All right, this is the sanctions court hearing. This is Ryan Dancer, Mr. Dancer. Let's see, I've got some notes here. All right, Mr. Dancer, let's just go ahead and kind of lay the groundwork of where we're at, okay? So you're on probation for a third-degree felony offense of indecency with a child. You were put on probation in August of last year. You've been assessed conditions of community supervision. Some of those include community service that you have to work, payments, reporting. And the purpose of sanctions court is when the probation department feels like a probationer is either A, not taking the probation seriously, is committing some either technical or non-significant violations. This court has a program where I bring probationers like you in to stress the importance of compliance and to try to get you back on the right path for success. And success is doing what you're supposed to do when you're supposed to do it so that you can get off of your probation when you're supposed to, right? Yes. And you're set to expire in August of 2027. So you haven't been on it very long. And the notes that I have here, Mr. Dancer, it says that because of the nature of your offense, you were having to take polygraph examinations, and that you failed one earlier this month regarding, I'm assuming, the use of internet. You're not supposed to be using the internet.
Yes.
And then also that you're currently unemployed and not working your 24 hours a month of community service, which they've instructed you to do. So tell me about your community service. Why are you not getting that done?
I was recently sick. I just haven't been feeling well.
Say it again.
I just haven't been feeling well. I was sick.
So you've done what, 50? You've already worked 50 hours, right? Where have you been working that? So you're working the whole week and getting 50 hours. That's a pretty good deal, isn't it? And the internet usage, that's a violation.
Yes, sir.
So what's the deal with that? You know you're not supposed to be doing that.
We got a new phone now, and figure out my relation and didn't dawn on me until I hit it. She brought it up.
What's your plan on getting your community service caught up?
Just work, because I'm not working anymore. Just work there.
What's your plan on getting a job and working?
Moving on scissors and that's what I'm.
When are you going?
When I leave here.
When you leave here? And you plan on working first Monday this month, the end of this month,
Yes, sir.
and you're gonna get your 50 hours?
Yes, sir.
And Mr. Dancer, I don't have your polygraph results. I haven't talked to probation about it. But you're telling me that the only time that you accessed internet was because you were looking for your probation officer's phone number?
Yes, sir.
Okay.
I can see.
All right, I'm gonna take you at your word, okay? But this is what we're gonna do. I'm gonna bring you back on March 28th. Is there a reset? You got one? Okay. I'm gonna bring you back on March 28th, okay? And I want to see 50 hours of community service. We're trying to get you caught back up.
Yes,
All
sir.
right, so you work that one first Monday weekend and you're caught up. 50 hours of community service, okay? For every 10 hours of that you don't do, we're gonna do a day in jail. Okay, for every 10 hours. So you're liable for up to 5 days in jail if you don't do your community service. We're gonna get you caught back up on that. I'm not gonna put you in jail for the internet violation unless that persists. If that becomes a problem, then
To that, being access off my phone.
and then I want you to have an update for the court on your employment. If you don't get the job at Long John Silver's, I want to know about at least 3 other jobs that you're trying to get.
Yes, sir.
Okay, on the 28th. All right, you're a young man, right?
Yes, sir.
Can you read and write?
Yes, sir.
Can you walk?
Yes, sir.
Can you lift things? You're a smart young man, aren't you? Then you can work, right? There's no reason that you can't find a job. All right, it's gonna take effort. All right, and I know you got some things that are making life difficult on you, but those are consequences of action. So life's gonna be a little bit harder now. So you're just gonna have to take that for what it is. You just got to work through it. There's been people who work through this every day. Okay, so it's not that it can't be done, it just has to be done. All right, so when you come back on the 28th, I want to see 50 hours community service for every. You're gonna get 10 hours, 1 day in jail for every 10 hours you don't do. You do all 50, no problem, no jail. You do 20 hours, then you're gonna do 3 days in jail. Does that make sense?
Yes, sir.
And then if you don't get this job, if you get this job, great, then you let me know. If you don't, then I want to know 3 other places that you applied for, interviewed for, made efforts to get a job.
Yes, sir.
All right? All right, go ahead and sign this notice of setting. We'll bring you back on March 28th. Are you Miss Dowling Wise? Okay, come on up. This is CR 23-11, Samantha Elizabeth Dowling Wise, set for arraignment. Miss Dowling Wise, is this your first setting or second setting? This is your first setting.
My first one, yeah.
Okay, and so you're charged with aggravated assault with a deadly weapon.
No, sir.
You're not charged with that?
I was charged with a felony assault violence of 2201, and they indicted me on a 2202, which I was not aware of. Also, I was not given the possible paperwork. My lawyer today, they said I didn't qualify, and I just found that out today. And I also talked to a lawyer, and they said we will call as soon as I leave here or whenever I leave here. So,
Do you plan on hiring an attorney?
looking into it, yes, I talked to Mr. Keeler today. And some of the facts that they have on the paperwork, which I haven't even, they just like indicted me on something I wasn't even charged with. So some of the facts is not correct anyway, and so I did tell him that, and he said to give him a call.
You are indicted with a second-degree felony offense.
Yes, but I was charged with a third degree.
I understand, but listen, I don't care what the police officers arrested you for, what they booked you in for. What I'm trying to tell you today is that the state of Texas, through their attorneys, have indicted you through the grand jury with aggravated assault with a deadly weapon. And so what I have to admonish you is that there is a range of punishment for that, which is not less than 2 years in prison, not more than 10 years in prison, and a fine not more than $10,000 if you're convicted and sentenced of that offense. And so I have to, make sure that you understand that, and so that you know how to prepare to defend yourself on that. Okay. And so if I grant you until March 28th, you believe that would give you enough time to hire an attorney?
Actually, a little bit longer, if so, because I'm gonna be finding out about this, and my dad had passed away when I was in jail, and so I haven't really had time to even let it came out.
Well, I'm not gonna give you more time. I'm gonna give you to March 28th. And if you don't have it done by March 28th, then you're gonna come in here and tell me why.
Okay.
If it's saving up money, you're gonna show me how much money you have saved up. And I need to know which lawyers you're talking to. I need to see effort on your part. And not all attorneys charge the same amount. So if you talk to one and they tell you it's $25,000, then I would call another one. I keep on calling around until I can find someone that I could afford. I'd ask for payment plans. I would figure out if do I have assets? Do I have things I can sell? Do I have things that I can get loans on? Do I have friends? Do I have family? I'd be doing everything I could if a judge told me I was facing up to 20 years in prison.
Okay.
Okay. All right. So I'm gonna have you come back on March 28th for arraignment and status on your attorney. All right, so Moreno, we don't have confirmation that he's in custody, so we probably need to do an outside warrant.
I showed that he was released to federal detainers, but I can't find him in the federal system, which is generally how that works, but it's not like I can't say that he has been released, I just can't confirm he is.
So we'll do it outside and then we'll wait. Maybe he'll pop up later. Okay.
Judge, you earlier say Mr. McKay, but there was a waiver of arraignment for April 6th.
Nolan White. And then Mr. Bowie will be here hopefully at 1:30. Said he has dialysis, and so in the morning, so we said afternoons are fine. That's a motion to vote.
And Judge, I can confirm that Mr. Lyons is no longer in the custody of Vanzant County.
He was released in 6.
He was here Monday for reset, making
All right, the court has called cause number CR 22-384, State versus Joseph Blake Moreno. Also CR 23-2, CR 23-14, State versus Takeithian J. Lyons. Neither individual was present when their name was called at 9 a.m. The names have been called loudly and distinctly in the courthouse with no response. The court hereby issues judgment nisi and alias capias for each individual. And that will conclude our morning docket. Court will stand in recess until 1:30.
Judge, just, that I told it to him, I sent you